Here we go. All right. Well, thank you so much, everybody, for joining. Happy New Year. My name is Amy Hom. For those of you who don't know me, I'm one of the co-chairs of AAUW California's Public Policy Committee. And we're so happy to have Kathy Harper here today to speak with us about Title IX. Kathy is my predecessor, the longtime director of public policy, and she has been an absolutely wonderful mentor. She now chairs the Public Policy Committee's School Board Project, and today she's going to share some information and updates about Title IX. Kathy, thank you so much. Over to you.
Thanks so much, Amy. Well, ladies, and I don't know if we have any gentlemen on here. A phrase comes to my mind from my mother's days. I find myself in a fine kettle of fish as I address you at 3:03 on this day, because about 1 hour ago, a decision was handed down from the district court in Kentucky that has completely changed my entire presentation. So I don't know if any of you saw it. It actually, the word came out in an announcement from Kalina in our public policy, one of our public policy staff at National, announcing that a district court judge in Kentucky has just rescinded all of the Biden changes to Title IX. Given this, that the subject of my presentation today is what the future holds for Title IX with the new administration, it's kind of become moot. And I actually found myself wondering, is this presentation even relevant at this point? But I think it is. I'm going to go ahead and go forward because I think there's still some really good information in there for you. And what I'm actually going to kind of shift my gears on is part of the presentation is a comparison of the old rules under Trump versus the new rules under Biden. And what this decision means is that we're actually going to go back to the status quo, or the state of the rules as they were under Trump. So we're going to go ahead and look through those, and that will let you know what we're going back to. So just a word about this decision. As I said, it came down from the district court in Kentucky, and because it's a federal court, it affects all states. So it goes into effect for every state regarding Title IX, the enforcement of the new Title IX rules, which they had just become effective August 1st of this past year, and they were immediately appealed. We had 26 states had filed appeals, and there was an injunction in place from one of those courts already pending resolution at the Supreme Court, but before it even got there, this district court decision came down. So we'll look more closely at what that means for the future, but the important and immediate thing that you need to know is that everything I'm going to tell you about the new Biden rules is out the window. They are, as of this ruling, they are no longer in effect. The judge said that, let's see, I just made a couple of notes here I pulled the decision, I had about an hour to read it, so. He said that the Biden administration overstepped the president's authority. It's scrapped the entire 1,500-page regulation after deciding it was, quote, fatally tainted by legal shortcomings. He said there's nothing in the 1972 law suggesting that it should cover any more than it has since Congress created it, which is hilarious because the regulations have been amended numerous times since 1972. They're amended, they're looked at by every president in whoever their Secretary of Education is, to determine whether they're relevant, to determine their relevance for current circumstances that change over the years, which is what President Biden did in addressing 3 key parts of the law that we're going to talk about. Nevertheless, this judge found that there's nothing in the law that says it should cover any more than it did since it was created. He called it an attempt to bypass the legislative process and completely transform Title IX. which is also laughable because the changes are always made by the Department of Education. They have to be approved by, they can be opposed by the legislature and they have to be approved by the president. But to say that it's an attempt to bypass legislature is again laughable. And then finally said that rather than carve out certain aspects of the rule, the judge decided it was best to toss out the regulation in its entirety and revert to the previous interpretation of Title IX, which in and of itself had been changed considerably by the Trump administration in 2020, 2019, and when the changes went into effect in 2020. He said his decision will simply cause a return to the status quo that existed for more than 50 years prior to its effective date, which again is not true because the status quo now is the changes the Trump administration made. I also want you to know, if you haven't seen it, that as I said, I got this news from Kalina at the public policy department from AAUW National. And Gloria, our CEO, Gloria Blackwell, has already come out with a public statement denouncing the decision. She said it makes it easier for schools to dismiss cases of sexual harassment and discrimination. It will now be harder to hold perpetrators of sexual harassment and assault accountable, and it will be more difficult for survivors to get the protections that they need. So, not starting off with good news here today. I'm so sorry to tell you. As I said, I'm going to go ahead and go through most of the presentation. I'll make modifications. I haven't changed my slides, but I'll make modifications as necessary as we go through it. I think it's important. We might have some new members, some new public policy chairs who aren't completely familiar with Title IX. So I'm just going to do a little brief background on what it covers and why it's important to us at AAUW. And then we'll look at those previous revisions so we can know what's in store for us for this year. So let's go ahead and get started. And at the end, of course, I'll have an opportunity to ask any questions, and I will answer what I am able to. So we'll still cover history and overview. We'll still look at some of the changes, not all of them. And future challenges is pretty much gone. The challenge is how do we live in a world where we lose these protections, but we'll manage. So what is Title IX? It's Title IX of the Education Amendments Act of 1972. Are you all seeing my slides?
No.
I just realized something. Let me see. I goofed. I'm sorry. I went to my, I goofed.
I wanted to say, I just happy.
No, it's my fault. I went directly to my slides instead of going to share. Sorry, now I have to find them. Hang on a second. Bear with me to bring them back up.
I wanted to just say one thing, that I was reading the news where a federal judge just opposed the Title IX preservation for the LGBTQ group.
Yeah, did you just come on, Myra?
Yeah, I did.
Yeah, because I just went through that whole thing.
Oh, did you?
Yeah.
I'm sorry. I'm sorry.
No.
I had trouble logging in, but I'm okay. Yeah.
That's okay. No problem at all. I just wanted to let you know so we didn't go through it again. If you have any questions, save about that decision, save them for the end because everybody else has already kind of heard that. Okay. All right. Now I got it. Now everybody's got this on their screen?
Yes.
Yes. Okay. All right. So this is what I was saying. This is the slide I was referring to, what we'll cover. And let me. Get that off there. All right, so what is Title IX? Title IX of the Education Amendments Act of 1972, this is when this first came into being, is a piece of federal legislation passed by Congress, and it was designed to ensure equal opportunity in education for all students from kindergarten through postgraduate school, as well as all employees of educational institutions receiving federal money, regardless of sex. So this applies to any and all educational institutions. It applies to both students and staff, teachers, all school staff. And a lot of people under the misconception that it only applies to athletics, which is not the case at all. It applies to many, many aspects, any aspect of any kind of discrimination that takes place on any public school campus. The actual language of the statute is very, very short. This is what it says is no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. So that's the basic language, and the Department of Education has the responsibility to implement specific policies and practices that are within the guidelines of this language. So that's why we get from administration to administration, we get changes in the guidelines. Those are general, those are, excuse me, excuse me. There, any changes are basically have to do with the interpretation of this language. So what does it mean when we say the basis of sex? What do we mean when we say programs and activities? What does that encompass? What does discrimination mean? What are the benefits or the denial of benefits? What kind of benefits are we talking about? That's what the, excuse me so much. That's what, when we talk about the regulations that come down from the Department of Education, that's what we're looking at, is how the specific language of the statute gets interpreted. And that's what changes from administration to administration. So what does Title IX actually do? Title IX and its related regulations provide guidelines, procedures, and tools for preventing and addressing inequities that can hinder students and employees' ability to succeed in school and beyond. So this is this whole concept of—
This was terrible.
Yeah.
Sorry, whoever's talking, please put yourself on mute. Thank you. Actually, it would be helpful if everyone would put themselves on mute. Okay, why do we need it? There's a couple points to be made here. By prohibiting hostile, threatening, and discriminatory behavior, Title IX protects the rights of all students to learn in a healthy environment. And this is really critical because when we look at the changes, both that were made by the Trump administration and then the remedies that were sought to be implemented by the Biden administration rules, this is really what it was all about, is the protection of all students. Because under the Trump administration rules and their way of thinking, not all students were equally deserving of the protection of the laws. And that really is the gravamen of Title IX, is to make sure that all students learn in a healthy environment. All have the opportunity to do so. These advantages extend beyond individual students to the nation itself. And this is another really important point, I think. We as a nation stand to gain a well-prepared workforce in which the brightest minds are allowed to advance. So if all of those minds are given equal opportunities to thrive at the school level, the hope, of course, is that those students will then grow into healthy contributing adults. Here's another common misconception. A lot of people think that Title IX is really designed to just about girls and women, just to help them. And the fact is that everyone benefits from Title IX's protections. It says all students. There's nothing in the language that specifies women and girls only are entitled to its protections. It offers no special benefits or advantages, but is rather gender neutral. It's designed to ensure equality for all students by electing any type of sex discrimination. So why do we care? Here in California, I've highlighted some points from our public policy priorities. And our pillar number two, two of our pillars are affected by Title IX. The first is equal access to quality public education for all students. And one of our priorities under that pillar is ensuring the vigorous enforcement of Title IX. And the other one is our pillar for social and racial justice for all members of society. Two of our points there are freedom from violence in all its forms. This is significant because one aspect of Title IX is the elimination of any kind of sexual harassment. And it also provides for remedies for when sexual harassment on campus is reported. And then the other is guarantee of civil and constitutional rights for all, including all forms of gender identity and expression and all family structures. And this is important to Title IX's definition, how each administration defines that term sex. What does that encompass? And for our purposes, it's important that it encompass these guarantees for all, including all forms of gender identity and expression. And as we'll see, the Trump administration guidelines did not include that consideration, whereas the Biden administration regulations do. It's an important distinction. So I have on these slides, I have all kind of a point by point comparison of all of the changes. We don't need to go through all those today, and they're not all particularly relevant, but there are some that we need to be very, very concerned about with this new ruling. So those are the ones that I'm going to highlight. So just to kind of bring you up to speed to where we are, well, after Trump was elected in 2017, he appointed Betsy DeVos as his education secretary. And she promptly and significantly scaled back the then existing Title IX protections, particularly in these two areas, as it pertained to sexual assault investigations when complaints had been lodged by students on campus at any level, but primarily colleges and institutes of higher learning were affected by her changes. And the inclusion of gender identity within the meaning of gender protections. She made a lot of changes in that arena as well. In 2024, after President Biden was elected, one of the first things he declared was his desire to reinstate the previous protections, particularly in these two areas. He directed his Secretary of Education to put out a call for public comment. That call elicited 240,000 comments from the public, and AAUW was very involved in that. We actually weighed in as a national organization as well as individual members of our organization. The result of that was a whole new set of guidelines, which were released in April of 2024 and became effective on August 1st. And the three main areas that were included that we really care about were changes involving sex-based harassment on campus, anti-LGBTQ plus discrimination, and discrimination against pregnant and parenting students. And this last one was something that had really not been addressed at all in the Trump administration changes. And so most of these were fairly new. So as I said, I'm going to go ahead and take you through some of these that I think we need to be particularly concerned about. Most of these and these original ones we're going to look at all three of these areas. And the first one is related to sex-based harassment. And then I put or other kinds of sex discrimination. The ones on this slide are mostly, they're minor changes. They're not anything that's going to make it that huge of a difference if we lose them. So I'm not going to spend time on those. This one I want to take a look at the standard of care. Again, we're talking about sexual harassment claims. The standard of care under the Trump administration was that school personnel must respond to a complaint only in a way that is not deliberately indifferent. It's a pretty low bar. That's all they had to show, is that they were not being deliberately indifferent. Kind of not proactive, whereas the Biden rule change in 2024 was very, very proactive and said that in fact personnel must respond with prompt and effective action. So that is gone now. So we will go back to a standard of care of being only deliberately indifferent. This is a really big one. I want you to take a look here at the hearing procedures standard. IHE is Institute of Higher Education. The old rule, and now the now rule, is that during investigations, so what happens, a complaint is lodged by a student, that triggers an investigation. And as part of the investigation process, under the old rules, the regulation was that the hearing officers must allow the parties' advisors to conduct cross-examination at a live hearing. That had changed from a previous rule before the Trump rule that did not require cross-examination and did not require a live hearing. So those were two new requirements that were introduced by the by Secretary DeVos. The Biden rule changed that to say that instead the school must interview each party and witness in individual meetings. They must have a decision maker interview all parties and witnesses at a live hearing, and that the school has the option of allowing cross-examination instead of it being required. So why is this important? Well, if we think about a sexual assault victim, a person who identifies themselves as a sexual assault victim, they make a complaint. And one of the major reasons that a lot of sexual assault victims do not make complaints is because of the nature of a hearing where they have to confront their accuser, where they're in in the same hearing room, and they're subject to cross-examination by sometimes an attorney. If the accused party wants to have an attorney at the hearing, they're able to. If they don't, they're representing themselves, they get to do the questioning of this complainant. So as you can imagine, it makes it extremely difficult for survivors to make their complaint in the first place, and to go through the kind of torture sometimes of these live hearings. So this was a significant change, one that we championed at AAUW quite vigorously, and that is gone now. Those protections for survivors are gone now, and we will now be back to the requirement of cross-examination and a live hearing. The second one in this area is regarding the standard of proof. The old rule was that the hearing officers must use either preponderance of evidence or clear and convincing evidence. Preponderance of evidence means that these are legal terms, and it means what the complainant has to prove in order to have their complaint sustained. So a preponderance of evidence simply means there's even just a little bit more evidence in favor of the complaint than there is against it. Clear and convincing is a very different standard, and it's much higher. And the old rule said that it would be left up to the individual institutions to decide which standard of proof they wanted to use. The new rule said that the schools must use preponderance of evidence unless the school uses clear and convincing standard in all other discrimination proceedings. This was important because what was being found was that for other types of disciplinary hearings or complaint procedures, the schools would use preponderance of evidence, but for sexual harassment proceedings, they would use preponderance of evidence. And the Biden administration determination was that this was not fair. It was discriminatory to sexual assault complainants, and that they either had to use the same procedure or they would have to use preponderance of evidence for sexual assault complainants. So that rule is gone. We're back to leaving it up to the schools if they want to use either. And again, the reason this is important is because it comes from a place of a starting point of disbelief in the complainant. And it says something, it's a value judgment that sexual assault complainants are generally untrustworthy and not to be believed, and therefore we must hold them to the highest standard of proof. In a criminal proceeding, that's beyond a reasonable doubt, because that makes sense, because that has very severe consequences for the perpetrator if they're found guilty. But this is just this is a school hearing. It is not a criminal proceedings. The consequences are nowhere near what they are in a criminal court. But yet this policy that we now have, because we've gone back to, as I said, it comes from that place of distrust of sexual assault survivors. And that's why many schools would use a different standard of proof. They would use a lower standard for ordinary hearings, but for sexual assault complainants, they had to meet this higher standard. So we are now back to that. The next area has to do with training requirements and monitoring of reporting. There were no rules regarding either of these factors under the Trump administration. The Biden rule sought to remedy that by requiring training for all employees on the recognition and reporting of Title IX violations, and it also required some additional training specifically for Title IX officials. And then with regard to monitoring of barriers, it said that this, officials must act to prevent discrimination, and they must monitor and address any barriers to reporting. So all of those rules now regarding training and monitoring, all of those rules are gone. Those requirements are gone, and there are no longer any requirements in either of these areas. With regard to the next area, so that everything I've just been talking about has to do with the handling of sexual harassment complaints on campus. The next area that's affected is regulations regarding anti-LGBTQ plus discrimination. And this comes again from the definition. If we go back to thinking the language of Title IX, it says no one shall be allowed to discriminate on the basis of sex. So what does sex discrimination look like? It was not addressed at all under the Trump rules. So there were no specific, what that meant was there were no specific protections for specific sexual identities. And again, the Biden rule sought to remedy that by introducing a very specific definition of sex discrimination that would be all inclusive. So the Biden rule's definition of sex discrimination was designed to include discrimination based on sexual orientation, gender identity, sex characteristics, including intersex traits and sex stereotypes. So very, very specific and very complete protection for our LGBTQ plus students, including our transgender students. And we're going to see in a minute why that is particularly significant. And then again, specifically with regard to transgender inclusion, it specified that schools must allow individuals to participate in classes and activities use bathrooms and locker rooms, and dress and groom themselves consistent with their gender identity. Both of these are all the protections under both of these two sections are all now gone. There are no longer any protections specifically for our transgender or LGBTQ students. Then the third area that is significant is as it affects discrimination against pregnant and parenting students. There was one regulation under the Trump rules that said schools cannot discriminate against students based on pregnancy or related conditions, including childbirth, termination of pregnancy, and recovery from any of these conditions. The Biden rule added lactation and medical conditions to be specifically included in the term included conditions. That is now gone. Nothing on in these particular rules that are earth-shattering. Leave of absence, one major change was, it says that the old rule said that upon return following the pregnancy leave, student must be restored to their prior status. The Biden rule included not only their prior academic status, but where practicable, prior extracurricular status. So for instance, if they were engaged in extracurricular sports, for instance, they would, where practical, they would have to be given their status, being reinstated as a member of the team, etc. So that's gone. The more significant changes are around accommodations. The old rule is that the campus must offer the same services and benefits as offered to temporarily disabled students. The Biden rule changed that language, and this was an important, I think, change, because that language, as you can imagine, envisions a pregnancy as a disability, and it included pregnant students as looked at them as disabled students. The language change was that they must consult, the school must consult with the student to offer individualized and voluntary reasonable modifications, unless the modifications would fundamentally alter the school's program or activity. And then it went on to define reasonable modifications to include such things as elevator access, a larger desk, footrest, breaks from class, absences, online courses, etc. Things that would particularly pertain to a pregnant student or a student recovering from pregnancy. So that's all gone. Back to the old rule that they only have to be offered the same services that apply to whatever the school's offers or provides to any other, quote, temporarily disabled student must be offered to pregnant students. Oops. Lactation provisions were not even addressed under the old rules. The Biden rule sought to remedy that by stating that schools must provide a private, clean, non-bathroom space for lactation. That requirement is gone. So schools are no longer under any obligation to address lactating students. Yeah, so those are the areas of the where we are going to lose certain protections and go back to the old rules. The next section that I had originally designed this to address were the future challenges. And we're still going to have challenges. They're just going to look different. They're going to come in a different form than what I have on here. So I'll pull these up and then we'll kind of look at where those changes, where those challenges are going to come from. Just a reminder, it's important to keep in mind what the functions of each of the branches of government do. I read just the other day that according to a new survey, only 32% of all Americans surveyed could even say what the three branches of government were, let alone what their differences were and their responsibility. And not that I'm assuming that any of you out there are among that 32 or 34%, but it never hurts to have a little refresher. So the legislative branch is responsible to pass, amend, and repeal laws and grant regulatory authority to the respective departments. The executive is charged with overseeing the Department of Education and directing and approving proposed regulatory changes to programs. And the judiciary finally ensures compliance with the US Constitution. So all three of these branches are implicated in Title IX. You remember I started this off by saying Title IX is the body that originally enacted, Congress, the legislative branch, was the body that initially enacted Title IX. So that's how we got Title IX. It came from the legislature. They passed it as a law. But the executive has the actual, so Title IX comes within the purview of the Department of Education. So that's a branch of, that's a cabinet position that is in the executive branch of the government. It's the Secretary of Education reports to the president. So there's overlap in that regard. And then the judiciary has the responsibility to review any law of Congress, so that would include Title IX, to ensure that it complies with the Constitution. So I had originally, again, wanted everybody to take a look at what could happen to Title IX. The legislature could repeal it. That is no longer going to be necessary. That's been repealed by the Kentucky judge, pretty much. So we don't need to spend much time on that. I did want to address just briefly, I have in here, could pass laws to curtail the authority of the Department of Education. They can still do that. They can still do it in other regards that we're very, very concerned about, but they won't be doing it with regard to Title IX, I'm assuming, because we have both a Republican House and Senate, that whatever new laws, if any, the new Secretary of Education comes up with, they can still review those laws, but I don't anticipate them disagreeing with anything that this administration comes up with. It's also worth taking a look at Project 2025, because Project 2025 goes beyond some of these Title IX changes. But here's what they do specifically address it, the authors in Project 2025. And I had stated that they could reverse the change in Title IX definition of sex to mean sexual orientation and gender identity, where that says that now. Title IX is proposing that be revised. What we could be looking at is that the new administration might decide to go beyond what is stated in the old Trump rules, where it doesn't include sexual orientation and gender identity. They could go further than that, and they could specifically put in the regulations that it excludes consideration of sexual orientation and gender identity. That's one of the things that we want to keep our eye on, is how far will they now go in the other direction. I think they're going to be emboldened by this decision. I think they're going to be emboldened by a lot of extremists that are currently in Congress and are clamoring for any way that they can to shut down protections for LGBTQ plus students, particularly transgender students. I said before that I wanted to put a pin in the changes regarding transgender students. That's really what was the impetus for all of these lawsuits. The main concern that was addressed was that the changes were now going to allow trans girls to play on birth gendered girls on in school sports. And I know there's a lot of controversy about this. I know that not all of our members agree on this. So that the point that I want to make is that Congress has taken a very strong position on this, whether you agree with it or not. The extremists in Congress, even some of the more moderate Republicans in Congress, have made this their, what do I want to say, their sword to die on. This was the primary thing that was raised in these lawsuits. And what's interesting is that this judge made a decision to not just limit it to this definition of sex. He said, I'm just throwing everything out, and used it as an opportunity to get rid of everything, all of the Biden administration changes, even though what was really itching at the folks who brought these lawsuits was this whole transgender thing. So I think we're going to be seeing, I'm predicting that we're going to be seeing some laws that go beyond what the old administration, the original Trump administration had done in this area. And I think we're going to see some very specific language about exclusions. We'll see. I could be wrong, but that's my prediction. I have restored due process, quote, due process rights to individuals accused of sexual assault and harassment. We already saw that now with this decision. Again, this reflects a tilt in the way that schools are going to be thinking about sexual harassment complaints. Are going to go back to the days of assuming that sexual assault survivors are not honest and to be believed. So that's not going to go well. The executive, as far as the executive branch, I could order the Department of Education to write new rules. Trump may or may not do that. The new secretary may or may not do that. And it may or may not even be important, because we're seeing a move toward completely dissolving the Department of Education. If that happened, or another possibility I have down here is that they could move the Department of Education's Office of Civil Rights to the DOJ. That seems probably more likely, rather than completely dismantling the Department of Education, just moving civil rights. The Office of Civil Rights is the division that oversees Title IX compliance. They could move that to the DOJ, the Department of Justice, and then order the Department of Justice to either to mitigate its power to investigate complaints of civil rights abuses. We just don't know what's going to happen with the whole Department of Education. There's already a bill that's been introduced in the Senate. It does require 60 votes to pass that bill, to dismantle the Department of Education. The general consensus at the time is that they probably are not going to be able to get 60 votes. They have a very small majority. So we can hold out some hope that that's not going to happen. But I don't want to get off. I don't want to use this as an opportunity to get off on a discussion of the Department of Education in its totality. We're really focused on Title IX, but it is important because Title IX does come within the Department of Education. So there's a lot that, of course, that's up in the air. We can all predict based on experience, and can kind of see the way the wind's blowing. But Project 2025 is something for us to really keep our eyes on, because it says a lot about Title IX. It says a lot about the Department of Education. It says a lot specifically about transgender rights. And they're all going to be affected. So, oh, the other thing is this last bullet point I think is worth taking a look at. I had said that they could end all ongoing investigations into reported Title IX violations. And that's something that I think has a high degree of likelihood by this Justice Department. I could definitely see the new President Trump ordering the Department of Justice to drop those investigations. And then finally, the judiciary, at the time I wrote this, I had said this was the current state. I put this together about 3 months ago because I originally gave this talk for one of the IBCs out here in San Luis Obispo County. And at that time, this was the state of the judiciary. 8 lawsuits had been filed challenging the new regulations. 26 had signed on. And the lawsuit in Kentucky was one of those 26. That's where that came from. There had also been an injunction that had been issued by the state of, by a district court in Kansas. I want to point this one out, even though, again, it's also moot. That injunction, that petition for injunction will go away now with this new ruling. But what's important about this is that it was a challenge by the Moms for Liberty group. And any of you who have been hearing me, listening to me talk about our school board project and the challenges that we're facing with our local school boards, a major player in this is the Moms for Liberty. And it's interesting to see that they not only are focusing on school boards and book banning and censorship curriculum, but they got their finger to Title IX as well. They were one of the major plaintiffs on this injunction. And when it was issued, it listed schools in 24 states that would be covered by the injunction. But it also said that any school that had, where any member of Moms for Liberty had a child in that school, it would also be subject to the injunction. So that just gives you an idea of the power that they have and that they've been accumulating and that they are going to continue to wield. And again, this decision, I think, empowers them to not only continue their quest to regulate all matters of sex in the United States, because that's really what all of it, all their book bans, all their curriculum censorship, it's all about sex in some weird way. So I think that we're going to see a lot more of them after this. This last case is no longer relevant, and none of this is relevant. This all has to do with interpreting regulations, who has the authority to regulate, and how the courts play in that. Same with this slide. We don't need to go there, and we don't need to go there. So everything else that I have is references, resources where I got all this information. So that's I like to say good and bad and ugly, but it's mostly ugly. I don't say much good in there. So that's pretty much brings us up to date where we are with this whole mess. And I'm at this point happy to entertain any questions that you might have.
Kathy, we do have a couple of questions in the chat. One from Sue Miller. Sue is asking if the Kentucky decision can be appealed.
Here's the thing, all decisions can be appealed, but who's it going to be appealed to? The US Supreme Court. Number one, what do you think they're going to do with it? And number two, it probably won't be appealed because the process takes too long. The Biden administration, the Department of Justice only has 9 days left to do anything. And they're not going to get an appeal filed in that time. And I can guarantee you 100% that nobody in Biden's Justice Department is going to appeal this decision. So it's pretty much what it is.
We have a question in the chat from Pamela, and then we'll come to you, Nancy. So Pamela Granger asks, does Title IX include staff?
It does. It includes pretty much anybody on a campus, a student, a staff member, an administrator, a janitor, anyone who has business on a public school campus is governed by Title IX rules.
Nancy.
Yeah, I don't understand in one of your original slides when you showed the 3 branches of government and how the education department under the executive branch can determine regulatory issues which have already been determined by the Senate and the House.
The legislature enacts the law. so whatever department that law affects then has a chance to put together rules and regulations that would allow that law to be implemented. So the law comes from the legislative branch, but the way to implement that, which we call rules and regulations, comes from the individual department that has authority over that act. Okay, so the legislature has an opportunity after those rules and regulations have been imposed, they have an opportunity to oppose those or to support them. And then the judiciary has an opportunity to review them for constitutional conformity. So there's overlap among all three of the branches.
Okay, so the executive branch am I correct in saying the executive branch cannot get rid of Title IX because it's already been approved by the legislature?
Only the legislature can repeal an act, a law that they have enacted, correct?
So all they can do is water it down.
All they can do is change the rules and regulations. They can change the way it's implemented, but the executive branch can't change the actual language of Title IX, but they can make changes in the way that it's implemented.
Okay, thank you.
The way that it's implemented is basically boils down to the directions that they give to individual school districts to implement the rules.
Okay.
Anything else? Amy, are you seeing anything else in chat?
I'm
No,
sorry,
I don't.
Kathy, this is Jean Reed. I sent a comment to you.
Hi, Jean.
Can you comment on California law that may provide additional protections to students?
You know, that's going to be really interesting to take a look at. We have probably the strongest protections of any state in the country. Here's the easy answer. If we have any rule or regulation or even law that conflicts with the Constitution or conflicts with federal law as it's been interpreted by the Supreme Court, or in some cases a federal court, then federal law holds sway. If it's not a violation, if it's not a direct violation of federal law or the Constitution, then we have a right to impose our own law. In this case, the judge is not making any determinations about Title IX itself. It's just saying that the rules that Biden administration imposed are no longer binding on school districts. So we can no longer go in, for instance, in our last script in the school board project, here's a great example. We added, after the Biden administration rules were implemented, we added a section that said, and remind your school board members that Title IX says they have to do X, Y, and Z. We have to take that out of there now because we can no longer, in our state even, refer to Title IX protections as a basis for our school boards to act one way or another. But we can still, as a state, we can still impose those regulations as our own law, not as a requirement of Title IX that has to be followed, but we can say in our state, we believe that this is the way gender identity, for instance, should be described or defined. As long as it doesn't conflict with our own Constitution. So there's nothing in the Constitution or in Title IX itself that says you can't interpret it that way. Right now, all that decision says is that you can't use Title IX as a basis for it any longer. Does that answer your question, Jean?
So I understood that we had passed a law in California that prevented the live cross-examination.
In California?
Yes.
Not that I'm aware of. I'm searching my brain. Amy, am I missing something?
I wasn't aware of that either.
Maybe it was my misunderstanding, but that was something that we could do.
We can still, well, yes, we can still preclude in, well, yeah, this is all new, so I'm having to rethink this. Schools that receive federal money are obligated to follow federal guidelines. So if the Trump administration came up with a rule through their Department of Education that said all schools must allow cross-examination, then we would not be able to, because our colleges accept federal money and some federal funding, they're obligated to follow that rule. I guess that is pretty much where we are now, given this new decision. We are back to the requirement for cross-examination. So yeah, so going through all that out loud, the answer is that as of this ruling, even our colleges have to follow that law because they accept federal funds.
And Kathy, I think there is a very related question in the chat from Kathy Long. She's asking, should AAUW California work with our legislators and the Department of Ed to craft legislation to protect?
Let me ask, are you asking about our state Department of Education or the federal Department of Education? Whoever asked that question.
That question was from Kathy. Oh, she's saying from the State Department of Ed.
Again, we already have really strong protections, but we cannot, even our own state Department of Education cannot promulgate any rules that are in conflict with federal rules that specifically require or specifically oppose any principle or regulation. So if it's open-ended, we're free to give our own interpretation. But if it's specifically set out that you have to do this or you can't do this, our colleges have to follow those guidelines. So it may not matter what our Department of Education does. This is also going to become really important in all of the recent laws that we passed, the protections for our transgender kids in schools. Because right now, the Biden rules are silent on that, but if they get changed to specifically exclude specific gender identity language, which I'm guessing they're going to do, then that could very realistically affect our recent laws.
Right, we have a question. Nancy, yeah.
Nancy, you're muted.
The New York Times today, just now, mentioned that the recent ruling included comments about the First Amendment.
Oh,
and
right.
Based on what you just said, that, he says that that Biden's rules force teachers to use language like a child's, a female, but they're called a male, to use language that is contrary to their beliefs and force them, in that sense, it's a violation of the First Amendment. So I'm wondering how you feel. That seems so broad that it really impacts California in the sense that, based on what you said before, we would be violating federal law. How do you see that, Kathleen?
He says that if I remember the language I read from, I didn't copy that portion, but he said that the requirement that teachers that teachers be required to use the gender identity that the child identifies with. Yeah. So if the child wants to be referred to as a female, that the teachers must refer to them as a female. The court said that that's a violation of the teacher's First Amendment right. It doesn't really have anything to do with their beliefs. It has to do with regulating their speech. And it says, he said it's a violation. I don't necessarily agree with that aspect of his ruling, and I think it was not necessary to the ruling. But if, but you raise a really good point, is that because this judge has made this a First Amendment, that's a constitutional issue, so that the US Constitution overrides everything else when it has to do with a constitutional violation or an alleged violation. So yes, that's a great example of something that our school districts could not impose on our teachers because it has now been determined by a federal judge to be a violation of their First Amendment rights.
Great. Jean Reed sent a note. She didn't share this with everybody, but I'm going to share it because Kathy, I think this is important. She found a law, SB 493, that went into effect January 2022. And this restricts the ability of parties involved in a sexual harassment complaint on a college campus to directly cross-examine each other.
I want to know why Jean isn't on our public policy committee.
Yeah.
I guess we both forgot about that law. 2022 was like, eons ago. It's good. I'm glad to know that we had that and that our memories have now been refreshed, Amy. Yeah, so let me think how that goes back to your previous question. So I would have to say that since the current department, with this ruling now, the current Title IX rules say that cross-examination is required. That means that all campuses that receive federal money are going to be controlled by that determination. So that, again, that's going to override our state laws.
Great. Well, Kathy, thank you so much. This is really informative, and I commend you for pivoting and doing a masterful job at changing your presentation with 1 hour notice after that ruling came down. This is great and very informative.
Good. Hope it helped. I'm always open to questions if you think of anything that's later on. Thanks, Amy.
Thank you. Thank you so much, everybody, for joining. Thank you very much, Kathy.